All right. I hope you're doing well wherever this video finds you. I'm sitting at home right now in the evening, getting ready for a trip, and all is well in my world. In the last video lecture, I spent some time discussing the legal reasoning from Roe versus Wade. And in this video, I'll be discussing and explicating some of the material that followed the Roe decision. Today, we'll be looking at, in particular, Planned Parenthood versus Casey and Dobbs versus Jackson. Now, a lot of time passes between Planned Parenthood versus Casey and Dobbs versus Jackson, but we're going to basically hit the high points of the history of abortion jurisprudence. In Roe versus Wade, the main thing to emerge from our discussion there was that abortion was putatively constitutional because it was grounded in a right of privacy. And what exactly was the status of that right? Was it a textual right? What is it? Was it a 14th Amendment due process right? Was it a Ninth Amendment right? A lot of that was unclear. We were left wondering where exactly privacy was derived from the text of the Constitution, weren't we? And so Planned Parenthood versus Casey will purport to solve some of these problems. But as we'll see, maybe the solution generates more problems in and of its own. So, what exactly was the case in Planned Parenthood versus Casey that garnered so much attention? Well, it was a controversial Pennsylvania law that prohibited 5 different things. Okay, let's see what these things are. The first is Section 3205, which requires, informed consent by giving the woman a cool-off period, a 24-hour cool-off period in which she was required to wait until the abortion was performed. So 24 hours of reflection, and only then could a physician perform an abortion. Section 3206 requires informed consent of one parent of a minor. So if the person was a minor, their parent must consent to that procedure. And 3209 is the one that gets us into this controversy, isn't it? It requires that a woman seeking an abortion must sign a statement indicating that she has notified her husband. A married woman, this only applies to married women, and so a married woman must sign an affidavit certifying that she has notified her husband, not received his consent, merely notified her husband. Section 3203 defines a medical emergency that permits an abortion to go on ahead, even in the absence of these other cool-off periods and requirements. And there is another provision that required a judicial bypass in case the person seeking an abortion was a minor and their parents were unwilling or for some other reason indisposed to grant an abortion. There was a judicial bypass procedure if the parental consent was unreasonably withheld. Okay. Sorry for the pause here. Just thinking about what I'd like to say next. All right. So at the time that Planned Parenthood versus Casey was heard, the general vibe on the street was that people were almost certain that abortion was done as a constitutional right deriving from the constitutional law. This was because of the justices that sat on the court at the time that Planned Parenthood versus Casey was heard. 8 of them were conservative Republican appointees, and only 2 of these justices had expressed explicit endorsement of the reasoning in Roe versus Wade, some of which were actually on the court at the time that this case was penned. And so virtually everyone thought that Roe versus Wade was going to be overturned. And so the decision of the Supreme Court in Planned Parenthood versus Casey was basically a bombshell. because Sandra Day O'Connor, who many presume to be a conservative justice, ended up siding with the idea that abortion should be maintained as a constitutional right. And likewise, Anthony Kennedy, from that point forward, was known somewhat as a social liberal. So the case was shocking to the legal world and to the world at large. But despite its surprising nature, I think the legal reasoning contained therein is going to be very familiar to you by now, because it really takes the same form as the argument from Roe versus Wade. But there are some differences that the Planned Parenthood versus Casey court has with respect to how the premises are supposed to be justified. Recall that one way I framed the legal reasoning in Roe versus Wade was to say that if some behavior is protected by a constitutional right, then if a state wants to completely prohibit that kind of conduct, they have to demonstrate a very strong, compelling state interest in doing so. The next part of the analysis was just to say that abortion is a kind of conduct that's protected by a constitutional right. And in the case of Roe versus Wade, the court held that abortion was enveloped by the right of privacy. And so from there, it just follows that in order to completely prohibit abortion, the state has to adduce this compelling interest they have in prohibiting it. But there are no putative, compelling state interests that would justify abortion, at least not at all stages. There might be a point at which the state's interest is sufficiently weighty so as to attach to an unborn life, but it isn't the case that for any fetus, the state has a compelling interest in protecting it, according to Roe versus Wade. And so from those premises, it just followed that a state may not completely prohibit abortion. How does the Planned Parenthood court seek to improve on the legal reasoning here? Well, arguably, what the court in Casey is up to is in launching a new defense and justification of premise 2. They're going to try to argue that abortion is protected by a constitutional right, but they're going to do so not by an appeal to privacy, but by an appeal to the 14th Amendment. How is that argument supposed to go? Well, in the 14th Amendment, American citizens are guaranteed that they will not be deprived of a liberty without due process of law. And so the simple move in Planned Parenthood versus Casey was just to say, abortion access is a liberty that is referenced and therefore protected by the 14th Amendment. And why would they switch it like this? Well, just like anything else in life, things come and go. Styles come and go. Interior decoration, fashion, all these things, scientific theories even, they come and go. They change with the times, oftentimes for the better, oftentimes they're improvements, but there are oftentimes fads that come and go, right? Some of these things we'd rather soon forget, like jeggings or something like that. I don't know. Maybe if you like jeggings, don't take it personally. I wouldn't wear them. But many things are fashionable, and then they become unfashionable as time passes. And the Supreme Court, I would argue, is much like this. There are certain kinds of justifications and species of arguments that may for a time persuade the court. But with the changing of the constituency of the court, so too will the arguments that fly. So too will be the arguments that are persuasive to that court. And so at the time of Roe versus Wade, a majority of those members constituting the court would be persuaded by an argument from privacy. But recall that there was a kind of objection to the idea that the Constitution generates a right of privacy. One kind of skepticism was inductive, and the inductive kind of skepticism works like this. Oh, look, just because you've identified that the First Amendment guarantees privacy in membership lists, and just because you've shown that the Third Amendment guarantees a physical privacy in one's home, and just because you've shown that the Fourth Amendment guarantees a kind of privacy against unreasonable searches and seizures in one's home, person, papers, effects, and things, and maybe because there is a Fifth Amendment right against self-incrimination, In other words, there is a right to protect personal information about yourself just because you've shown that there are rights of privacy in those contexts. It would not follow that there is some more general right of privacy that would also protect, say, a right to contraception and a right to an abortion and all these other things that used to be thought to be protected by the right of privacy. So one kind of skepticism toward the right of privacy is just inductive. How do you get from all these particular instances to a more general right that can protect more stuff than just the stuff that's explicitly guaranteed by the Constitution? So I'll call that kind of an inductive skeptical argument. The second kind of argument that might persuade someone that there is not a strong and robust constitutional right to privacy is something along the lines of Anita Allen's equivocation argument, right? Oh, just because you've shown that the Constitution protects physical and informational privacy, it might not follow that the Constitution protects decisional privacy. And all these things regarding abortion and contraception, they sure seem to involve decisional privacy. Moreover, we're not even sure that decisional privacy is even privacy, so-called, because it seems a lot like a synonym of liberty. What is decisional privacy again? Well, it's just this ability to make decisions free of unwanted interference from outside parties. But that seems like what liberty is. It seems like what freedom is. This ability to do stuff without people meddling, without people getting in my way. So is this decisional privacy really privacy of the kind guaranteed by the Constitution? Maybe not. So those are some reasons why someone might be skeptical of a privacy-based argument for abortion. And with the changing of the tide and the changing of the court and the introduction of new members and the retirement and death of other members, the arguments that used to be persuasive from privacy no longer hold as much weight. And so the court, attempting to improve on the legacy of Roe versus Wade, sought to secure abortion rights in a new way. And the way that they decided to do this was by appeal to the 14th Amendment. Now, in addition to the 14th Amendment, you might think at the end of the day, there's not a very robust kind of argument from the 14th Amendment to the constitutional right to an abortion, because all the 14th Amendment says is that you can't take away a liberty without due process of law. And liberty, by the way, seems like a very expansive and broad term, reasonably susceptible to many different interpretations, many of which are going to be based on someone's moral, religious, and ethical presuppositions. And so how do we get from this sort of vague, undefined concept of liberty down to a very particular statement about what liberty permits one to do, free of encumbrance and interference from outside parties, right? So to sort of head off that kind of skepticism, what the court in Planned Parenthood versus Casey attempts to do is to ground abortion rights not just in the 14th Amendment, but also in the idea that it's important to stand by what's decided. You might recall that in a previous lecture, I chronicled Philip Bobbitt's 6 modalities of constitutional interpretation. One of the modalities of constitutional interpretation was this idea of doctrine. What a court ought to do, or interpretation is fixed by, what's come before it. Of course, this is all familiar to us because we took civics class in high school, but this is exactly what the court is going for here. It's kind of argument based on what's already been decided. And since Roe versus Wade already put an abortion right on the map, as far as the Constitution is concerned, it's the thing to do. Now, what's offered as a rationale for following stare decisis, because at the end of the day, right, we do have this lingering question about how often should I, in fact, follow what's been said before? I mean, if you look at the history of the United States, you'll find a lot of deeply disturbing and unsettling laws which have been made, many of which have been discriminatory, and they've discriminated against immigrants, ethnic minorities, and females, just to name a few. And so you might think, stand by what's decided. Why would that ever be a good idea, given our propensity for making these manifestly unjust laws, right? So it seems like something more is needed in addition to just the blind appeal to stare decisis. You can't merely appear to stare decisis to do the justificatory work that you'd like of it. And so what makes it the case that it's okay to appeal to stare decisis in one particular context? Well, Planned Parenthood versus Casey provides an answer for us. The answer is supposed to be that the public will lose all sorts of faith in the Supreme Court as an institution if it's too fractious and its decisions oscillate back and forth between the permissibility and impermissibility of something so significant as the right to have an abortion, right? So why is it the case that we can appeal to stare decisis in this one case? Well, if we don't, the public's going to lose faith in the institution of the Supreme Court altogether. And so the Planned Parenthood versus Casey Court concludes that stare decisis ought to be followed, and the central holding of Roe versus Wade, which is a constitutional right to an abortion, ought to be upheld because of the potential to lose public trust in the Supreme Court. Now, in what follows, I'm going to switch to think about Dobbs versus Jackson, because Dobbs versus Jackson provides a litany of criticisms of this form of reasoning, none of which would be original to me. But I also wonder about one thing, and it's the idea that there might be wrong kinds of reasons on which we would interpret something like the Constitution. But let me just say a bit more about what I mean by a wrong kind of reason before I actually jump into that kind of argument. This is me attempting to push back against what's just been said in kind of a novel way. And you might think about it and let me know if I'm on the right track. Maybe I'm just a talking head. I'm not trying to indoctrinate anybody. I think it's just interesting to think about. So, suppose there's a person who goes to a bar, and what they intend to do once they get to this bar is find somebody to hook up with and cheat on their partner. They'd like to cheat on their partner with someone, and as the night goes on, they drink more and more. And unfortunately for their plans, by the end of the night, they've become so inebriated that they can't move. They're basically glued to the floor, vomiting or whatever you want to imagine in this scenario. And so at the end of the night, some random stranger packs them into a cab and sends them back home. Now, has this person done the right thing? Well, they haven't cheated on their spouse at the end of the day, right? I mean, haven't they done the right thing? They abstained. They were faithful. They didn't mess around. We're supposed to have the intuition, though, I think, that this person is not acting in a way that's praiseworthy. Why? Because their conduct has conformed to this norm of fidelity for the wrong kind of reason, right? They didn't cheat on their spouse because of the normal good reasons for doing so. You shouldn't cheat on your spouse or your partner because you love them, right? Or you care about them and you don't want to do those things that would undermine your relationship with them, all of which would be good moral reasons for acting with fidelity, right? And what this person has done is they have done the right thing of not cheating, but they did so not in a way that was really in line with their desires or was really up to them. They just became so inebriated that they were incapacitated pretty much and couldn't carry through with their plans. And so it looks like they've done the right thing, but they've acted on maybe the wrong kind of reasons, something like that. Maybe there's an epistemic case that motivates this idea too. A famous one is Pascal's wager. Pascal had this idea that what you really ought to do is believe in God, because God exists and you believe in him, you're going to get infinite pleasure in heaven. But if God does exist and you don't believe in him, you stand to get like infinite pain in hell. So really what you ought to do is believe in God, because you'll at least get the infinite pleasure. It's a safer bet to just believe in God. Yeah, I mean, there are these other possibilities that figure into Pascal's wager too. Maybe God doesn't exist and you believed in him, so you falsely believed in something that didn't exist. But if you do that, what do you really have to lose? I mean, maybe you gambled a little less, maybe you smoked a little less, maybe you drank a little less, maybe you know, maybe you did something else that wouldn't have been in line with traditional theistic morality. Or maybe you complied with with theistic morality in a way that deprived you of some pleasures. That's what I'm trying to say. But ultimately, how much worse off are you really? And if you just disbelieved in God and he didn't exist, then the pleasure you get from that, it's only a minimal amount. At least when we put infinite punishment in hell and infinite reward in heaven, those swamp all the variables. So really what you ought to do is believe in God. Now, Pascal's wager has come under criticism because of the idea that what he's invited us to do is base our belief on a wrong kind of reason. Because many people argue that what makes a belief correct is for it to be evidentially justified. So a belief is good if it's justified and based on lots of evidence. That's what makes a belief good or bad, not the fact that if you believe something, it'll get you a lot of pleasure. That seems like the wrong kind of reason for belief. Okay, so now that I've done just a bit of setup, let's take our remark about the wrong kind of reason and reapply it to the Supreme Court's legal reasoning. I invite you to consider this question. Is an appeal to stare decisis and the idea that public trust in the Supreme Court as an institution would be shaken, is that a wrong kind of reason for the legal reasoning? The idea here would be the right kinds of considerations that bear on whether an interpretation of the Constitution is correct are those that relate to perhaps other modalities of interpretation, or it might be a kind of stability to the law. But the fact that other people might not trust the Supreme Court seems like the kind of thing that's irrelevant to what makes an interpretation good or bad. Imagine you have an interpreter of historical documents. Say you have a theologian who interprets a scripture or something like that, and he decides to publish an interpretation of a difficult text. And he does so not because he thinks it's what the text means, but just because public trust in him would be shaken if he published anything else. Doesn't that seem like the wrong kind of reason for publishing an interpretation? I don't know. I don't know what you think about this, but I invite you to reflect more about whether this appeal to stare decisis, or as my constitutional law professor told me, the ode to stare decisis, is a wrong kind of reason for interpretation. I leave that with you to ponder and consider. But what I want to do now is really turn our attention to the case that undoes it all, right? Dobbs versus Jackson. And I'm not going to spend any time talking about the setup because the setup is odd. It's a direct challenge to abortion jurisprudence that originates in Missouri, and I do feel a bit bad for the government attorney who's tasked with fending off challenges to existing constitutional law pertaining to abortion. He had a tough job that he didn't foresee, given the stability of the law. But I'd like to take a moment to tell you about the interesting feature that I think is brought out from Dobbs versus Jackson. That's the idea that Dobbs versus Jackson involves what is basically, if you strip away all of the nitty-gritty details, what you find in Dobbs versus Jackson is just a very simple application of the law, the logical law, known as modus tollens. Okay. Let me give you a stupid, hokey little example about modus tollens. Suppose that in a world, if Shrek lives in the swamp, Donkey must live with him as well. Okay. Suppose that is the universal discourse here. So I have this argument, right? It says, if Shrek lives in the swamp, then Donkey would live with him. But Donkey doesn't live in the swamp. So Shrek doesn't live there either. Something like that. If P, then Q, not Q, therefore not P. That's the basic form. And so what do we find in Dobbs versus Jackson? Well, recall earlier that in the concurring opinion of Griswold versus Connecticut, we saw a concurring opinion authored by Justice Goldberg. Justice Goldberg said that a right to privacy to be justified would have to be justified by an appeal to what has been rooted in the nation's history and tradition. And he thought it was quite plausible, as perhaps do I, that if you look at the nation's history and tradition, you will find an affinity generally toward privacy. People throughout the history of America, at least from this sort of armchair history I'm doing, favor their privacy. People like their privacy in America. And because it's rooted in the nation's history and tradition, there is a kind of pushback you can give to a skeptic who would, upon you announcing as a judge that you found a new constitutional right, you have the resources to say that this constitutional right is not just a figment of your imagination or a manifestation of your own political, religious, and moral presuppositions that have manifested into your judicial opinion. Because what you're really doing as a judge is appealing to something beyond you, something objective, something extramental, something that goes beyond your mind. You're appealing to what can be objectively shown to be rooted in the nation's history and tradition. It's rooted in the collective conscience of the people. And so, as a judge tasked with interpreting the Constitution and at sometimes announcing things that seem not to be explicitly mentioned by the Constitution, you have this recourse as a judge to the history and tradition of the nation as an objective test of what really is a liberty, perhaps, or either secured by the 14th Amendment or one of the kinds of rights left to the people in the Ninth. You have the resources to show that whatever you've announced as a liberty or an unenumerated right goes beyond just you as the judge. And it's that kind of sentiment from Justice Goldberg that forms a premise in this argument developed in Dobbs versus Jackson, because what the court there wants to do is show that if abortion is grounded in the 14th Amendment, then it would also have to be rooted in the nation's history and tradition and implicit in the concept of ordered liberty. That's premise one of the argument in Dobbs versus Jackson. If you strip away all the details, this is what you're going to find. If abortion is really a 14th Amendment due process right, it must be rooted in the nation's history and tradition and implicit in the concept of ordered liberty. The second premise of this modus tollens argument is, but abortion is not rooted in the nation's history and tradition and implicit in the concept of ordered liberty. Therefore, abortion is not grounded in the 14th Amendment. Now, the argument, as far as I can tell, is interesting, and the court engages in protracted historical analysis. And I, as a philosopher, don't really have the resources to go toe-to-toe with the court on anything they say about the history of the nation. Prima facie, it just seems like, from the puritanical origins of the country, it seems plausible enough that perhaps those kinds of people wouldn't exactly be on board with abortion. Fine enough and granted, to some extent. But to do a total analysis of the history and tradition of the nation seems something else entirely. So here's what I'd like to do in the time I have left today with this lecture. I'd like to chronicle and maybe push back against some of the things that might rankle you about the reasoning here. In what follows, I kind of want to develop three basic lines of pushback against the reasoning in Dobbs versus Jackson. Things that, when I read the case, I worry about. I worry that the reasoning might not be adequate for various reasons, and I invite you to think about this on your own time as well. But again, the basic structure of Dobbs versus Jackson is modus tollens. If abortion is really this right secured by the 14th Amendment, as was said in Planned Parenthood versus Casey, then we would expect it to be, rooted in the nation's history and tradition. But abortion is not rooted in the nation's history and tradition and implicit in the concept of ordered liberty. So it's not grounded. Abortion isn't by the 14th Amendment. That's the basic form of the argument. It has nothing to do, I don't think, though the astute reader might find one reference to such an idea, has nothing to do with the idea that Roe versus Wade was equivocal, though you might find one reference to this idea in the court syllabus later on in the text. See if you can find it, actually. That would be interesting. I'm going to ask you if it appears, yeah, in the next writing assignment, maybe as a little bit of a aside, I will ask you to what extent this reasoning depends on the idea that the reasoning in Roe versus Wade is equivocal. And the answer, I think, is that it doesn't really depend on it, though it is referenced. And if you can find that quotation, you'll be a superstar, right? It's there, I promise. There is one reference to the idea that reasoning in Roe versus Wade is equivocal. But to me, it doesn't seem to be the thrust, if you will. It doesn't seem to be the main driving feature of the reasoning here. The main feature of this argument is that if abortion was grounded in the 14th Amendment, it would also be rooted in the nation's history and tradition and implicit in the concept of ordered liberty. So here, I guess, are three kind of lines of pushback against the Supreme Court's reasoning in Dobbs versus Jackson. One idea, which will come up again next week when I talk about equal protection arguments from the Constitution for abortion. A lot of people will say, look, if you look at the constitutional law, what you'll find are appeals to a right of privacy or appeals to 14th Amendment substantive due process rights to ground abortion. This is all you'll find in the constitutional law as it's written. However, that's sort of odd because there are other ways that one might have expected abortion to be justified constitutionally. One of those ways is through appeal to the Equal Protection Clause. The Equal Protection Clause is supposed to prohibit, at least now, invidious forms of discrimination. And so you might think that a restriction of access to abortion is in some way a discrimination against those capable of becoming pregnant. And since it's that kind of discrimination, it ought to be considered violative of the Equal Protection Clause. And so you might get a new argument, as of yet unmade in the constitutional law, that abortion ought to be considered, abortion restrictions ought to be considered unconstitutional. And I'm going to present some of these arguments in greater detail next week when we look at a second piece from Anita Allen in which she analyzes these equal protection arguments. Now, her position, just to let you know right out the front, is that any kind of argument that can be made to advance abortion ought to be pursued because abortion is an important human right. That's her position. And I think that if you look through some of what she says and you read between the lines, I think she is a proponent of equal protection arguments for abortion. But she is, the central task of the paper we'll read is kind of to chastise people who would too quickly abandon a privacy-based abortion jurisprudence. That's the basic preview about what the Anita Allen piece will be. And I think it's a somewhat compelling argument that should be dealt with. And so because I understand the weight of those equal protection arguments, I find it just a bit surprising in the text of Dobbs versus Jackson, where they say that it is not possible for the Equal Protection Clause to arise in a discussion involving abortion because the court has previously held that restricting access to abortion could not be an invidious form of discrimination against women. If that's not verbatim, that is a very close paraphrasing of what the court says in Dobbs versus Jackson. Now, this is odd to me, and it's odd for one particular reason. The court in Dobbs versus Jackson basically mocks the court from Planned Parenthood versus Casey for their ode to stare decisis. Oh, you shouldn't have focused so much on stare decisis. This was a poor thing to do. Of course, stare decisis is such a limited doctrine, and it's oftentimes misleading. And yet, with how much justification for why it's permissible in the case of dismissing the Equal Protection Clause, we get this appeal to stare decisis, don't we? So it's this tool that's kind of ad hoc levied against, some of the things that the court disfavors. And that feels unsatisfying, right? We need further application. We need further explanation about when it's permissible to appeal to stare decisis and when it's not, right? So again, what's happened here is that there is this sort of argument that's prima facie plausible for the constitutionality of abortion that appeals to the Equal Protection Clause, and which we'll read more next week. And the court in Dobbs versus Jackson, though they think the Planned Parenthood versus Casey court is so silly for their appeal to stare decisis, appeals to stare decisis to sustain the idea that it's not possible for abortion access restrictions to be a form of invidious discrimination against women or females, people capable of becoming pregnant, whatever you'd like to say in that context. That's something I think that deserves more scrutiny from us. The second weakness, I think, of this overarching argument in Dobbs versus Jackson is that I'm not sure it actually comports with the history of the constitutional law when it formulates the premise that says that a practice must be both rooted in the nation's history and tradition and implicit in the concept of ordered liberty. Now, if you think back to the concurring opinions that we saw in Griswold versus Connecticut, there were two different concurring opinions. And one justice said that the right to privacy was justified because it was rooted in the nation's history and tradition. But a second justice opined that the right to privacy was implicit in the concept of ordered liberty. And so it seems like there are two different ways in which one might justify an unenumerated or non-textual right or a substantive due process right by appeal to either one of these tests. And I think that if you look at the constitutional law, it too would support the idea that these are not just one test, but two. There are two different ways in which one might justify the idea that a liberty, under the guise of a substantive due process right, is in fact the thing that the Constitution protects and isn't the thing that is a product of the judge's machinations, right? And so it's very odd that the court in Dobbs versus Jackson collapses these tests into one. In fact, they go so far to say that really all it is for something to be implicit in the concept of ordered liberty is rooted in the nation's history and tradition, or that it really couldn't be implicit in the concept of ordered liberty unless it was also rooted in the nation's history and tradition. It's a second oddity that doesn't sit well with the way the court progressed, I don't think. And I don't think it really is historically defensible. I think that if you were to look at the history of the Supreme Court, you'd find that these are two different tests that have now been blended into one. And so it doesn't seem like good historical analysis to me. A third kind of weakness, though, seems to be a reservation about the nature of historical analysis conducted by the court itself. Now, the court looks at many different sources, but one thing you'll note is that they deal almost exclusively with legal history, right? Think about why that might be problematic. Well, here's an argument that I've thought up over the years. Recently, I heard about this, I hope you did as well, but in Tennessee, there was a law that banned in some contexts drag shows, right? Performing in drag was outlawed in certain contexts. And if you just looked at the legal history of the United States, right? It goes from a state of having no laws prohibiting drag shows to all of a sudden having a law that does prohibit a drag show in Tennessee, right? And so one way of characterizing the legal history of this is to say there are more laws than ever prohibiting drag shows. Now, can you infer from that a kind of societal attitude toward drag shows? The law has been increasingly harsh and constrictive with respect to drag shows. So can we infer that salient cultural attitudes, the zeitgeist of this country, is getting worse toward the idea that it's permissible to perform in drag? To me, that seems implausible. To me, it seems like at this point in time in the nation's history, more people than ever are willing to accept drag performers. They're more open to the idea that drag show might be culturally valuable. People are more open-minded and accepting than ever. And so it seems to me that the mere fact that there is now a law prohibiting drag shows in Tennessee is not really a good way to get at what the cultural attitudes are. And one reason why this might not be a good inference is because what the law happens to be isn't necessarily reflective of the cultural attitudes that are held. Now, of course, they might be. They might be too. The laws held by a country might be perfectly reflective of the attitudes that are held by the people. But there's reason for skepticism about thinking that just because the legal history tells one story, in fact, the collective conscience of a people is in line with that legal history, right? And it seems to me that what the test requires, when it requires that we analyze the history and traditions of a nation, it seems like that kind of analysis is satisfied by something broader than just legal historical analysis. Okay, so what have I done in this lecture? Well, what I've shown you is that in Planned Parenthood versus Casey, the court has sought to improve upon the reasoning in Roe versus Wade. The reasoning in Roe versus Wade employed an outmoded form of appeal to privacy arguments that was later disfavored. Although I think the master kind of argument for abortion in both cases has a very similar structure. You might note that. It seems like they both have this kind of, if a behavior is protected by a right, then in order to curb that behavior, a state must, demonstrate this compelling state interest and whatnot. And there are minor differences between Roe versus Wade and Planned Parenthood versus Casey that deal with trimester frameworks and viability and undue burdens and whatnot that are largely immaterial for our purposes. What is sort of similar and relevant for our purposes is the idea that the legal structure of argumentation remains broadly the same. Now, the most interesting distinction between Roe versus Wade and Planned Parenthood versus Casey is this idea that abortion is thought to be a constitutional right in Roe versus Wade because it derives from a privacy right, be it non-textual, be it textual, penumbral rights. I still don't know what this is. Be it a Ninth Amendment unenumerated right, be it a 14th Amendment due process right. The court is non-committal about what kind of right it is. They just think it is a right somewhere. And Planned Parenthood versus Casey, the court says, enough. We're going to take a hard stand on what kind of right this is. It is a 14th Amendment due process right. In other words, when you read the 14th Amendment and it guarantees that one may not be deprived of liberty without due process of law, that liberty is the kind of thing that encompasses abortion. And also, by the way, we're not going to abolish abortion because of stare decisis. It's already been decided, and if we did this now, there would be disastrous loss of trust in the Supreme Court as an institution. And so we just won't overturn the central holding of Roe, which is the idea that there's a constitutional right to an abortion. Okay, so Dobbs versus Jackson, a very recent case that unravels this line of reasoning, I think. I think it does so somewhat effectively. It's just the idea that one will naturally be skeptical anytime a judge announces that they've discovered a new right, a new liberty, a new reference of the term liberty in the Constitution, a new right that was not unenumerated. Oh, how have you discovered this, Mr. or Mrs. Judge? Is this really just the product of your imagination and political bias, or is it really a right? Well, Dobbs versus Jackson appeals to that kind of skepticism. And the argument is a modus tollens argument that says, if you announce this kind of right, you bear the burden of showing that it's rooted in the nation's history and tradition and implicit in the concept of ordered liberty, whatever that latter concept means. But if you look at Planned Parenthood versus Casey, and if you look at Roe versus Wade, although there is some mention of the history of the nation, there's no protracted historical analysis purporting to show how abortion is rooted in the nation's history and tradition. And so Dobbs versus Jackson contains a protracted historical analysis of ways in which the common law and all these writers from antiquity disfavored abortion. And I've highlighted, I think, at the end of the lecture, 3 ways you might be suspicious about this line of reasoning. One of these dealt not so much with the form of the argument itself as it did the way they've precluded the possibility of considering equal protection arguments. The second kind of weakness stems from the idea that they've put together two tests, which have historically seemed to be two distinct things. And the third weakness was that our analyses of legal histories really sufficient to tell us what's been rooted in the nation's history and tradition. It seems like an incomplete picture of the attitude of the people. So look, that's all I'm going to say about this. In the next lecture, I'm going to explicate Anita Allen's piece in which she argues that abortion finds a better home in the Equal Protection Clause. So I think we're actually getting pretty close to our next major writing assignment. And just to give you a preview of what I'm going to talk about there, or ask you to do rather, I'll ask you to summarize the arguments from Roe versus Wade and Planned Parenthood versus Casey. I'll ask you to give me examples of equivocation and explain how Anita Allen says, explain exactly what Anita Allen's argument is that Roe versus Wade contains an equivocal argument. I'll ask you whether this equivocal argument is something on which the dissent in Roe versus Wade depends. I'll ask you if Dobbs versus Jackson depends on this idea. And then I'll ask you your own personal opinions about whether any of these arguments threaten Roe versus Wade, or whether Roe versus Wade might be the sort of thing that you'd like to improve on as well. And by the way, I think a lot of students are afraid that perhaps they'd express a political opinion that angers the instructor of their class or something like that and causes the instructor to be biased against them. And really, I don't think I could be further from that kind of professor. I think that one time I had a student named Ashley when I was a teacher at Texas Tech. And Ashley's first draft of her paper was a pro-choice paper that was argued very poorly. It was just a reiteration of the idea that a woman has a right to choose. And there was no new information offered from that. But the point of a philosophy course is really to sort of argue these difficult ethical matters in a compelling and robust way. You want to see creative, insightful, well-defended, and robust arguments. And a repetition of a platitude really doesn't do that. And so I gave her, that kind of feedback on her assignment. And what do you think I got when the second draft came in? It was an endorsement of the pro-life position. And that is just not what we're up to in philosophy. We want to see well-defended and rigorous arguments, things that involve creative and persuasive arguments. And I can tell you right now that you can argue for anything you like in this course. You could be the most staunch pro-choice, pro-abortion advocate. You might be the most religious and conservative person. And whatever you say, I wouldn't discriminate against you for the viewpoint expressed. But what I want to see is you giving thoughtful consideration to the ethical and legal issues associated with these things. And so I'll ask you your own personal opinion about this too. I want you to tell me whether you think these arguments from Anita Allen against Roe versus Wade are persuasive, or whether whether they succeed, or whether they could be improved upon, or whether Planned Parenthood versus Casey was a better ground for constitutional abortion rights, or whether the equal protection argument might carry the day. There are many different ways to a good answer to this question. I don't want to frustrate anyone. That'll be the second writing assignment. So hang tight. I hope you're enjoying the course so far. I'm really enjoying making these videos and thinking again about all of these issues in the constitutional law. And I'm excited to come back next week when we talk about Anita Allen's second piece. So have a nice week. I won't be on Zoom this Friday because I'll be traveling, but I do wish you the best. Please reach out with any emails or questions you have and keep up the good work. Thanks.